Good morning, everyone. My name is Robin, and I'm part of the Conflict Dynamics team. A warm welcome to our webinar on investor-state mediation opportunities in Africa. A big thank you for joining us. In our webinar today, we are joined by a global panel who are going to talk about investor-state dispute settlement and opportunities for mediation in Africa. Before I hand over to our speakers, I invite everyone to please join us in the conversation by using the Q&A or the chat function. We'd like to hear from you all. And lastly, enjoy the discussion. Felicity, over to you.
Thank you, Robin. For those who I don't know, I'm Felicity Steadman, and I'm a director at Conflict Dynamics in Johannesburg. And I'm also head of the mediator training faculty at CEDR. So we have a close relationship with CEDR. Conflict Dynamics is a mediator provider organization and training organization in South Africa. We were established in 1996. And I think it's safe to say we have pioneered civil and commercial mediation in South Africa since 2007 with the support of CEDR on that journey. So thank you, James. Our session today is an example of the ways in which Conflict Dynamics and CEDR collaborate to advocate for the use of mediation from the southernmost tip of Africa to London and beyond. I have two other hosts with me today and our panel, and I'm going to ask James to introduce himself briefly, and then Chris, and then I'll introduce our panel.
Thank you, Felicity. Good morning or afternoon, everybody. It's a real pleasure to be on this webinar. My name is James South. I'm the Chief Executive of CEDR, and as Felicity said, CEDR and Conflict Dynamics have worked together for many years in developing commercial mediation in Africa, and also we've worked in places like Nigeria with Fumi and others. So it's a pleasure to be talking about maybe a new development of mediation and investor-state disputes, which I started working on and knew nothing really about investor-state disputes, I have to say, about 7 years ago, until I started a conversation with Wolfgang Kumburg, another Sudan mediator, and ICSID, and the Energy Charter Treaty about the possibilities for mediation. And a lot of things have moved very quickly since those 7 years. And I think there is a prime opportunity to look at mediation in this space. I look forward to discussing that in the next hour or so.
Thanks, James.
Good day, everyone. My name is Chris Todd. I'm a partner at the African law firm Bowmans. I'm based in Cape Town and have until relatively recently led our dispute resolution practice across the continent. I trained as a mediator with CEDR in 2007, but am relatively new to thinking about the importance and value of mediation in investor-state disputes in particular, and also beyond that into commercial cross-border disputes. But it's great to be here and great to have a panel to talk to this morning.
Thanks, Chris. The purpose of our session today, as Robin has said, and in referring to the title, is to explore how investor-state disputes are settled in Africa, and then to consider how we might promote the use of mediation in these disputes. So we will refer to how disputes are currently resolved, and then we want to focus on, well, how can mediation be helpful? What does it look like in these sorts of disputes? And what might the differences be and the challenges be in promoting mediation in investor-state disputes? Let me introduce our panel, and I'm going to start off with Clement. So Clement Mkiva is a partner and team leader in the Bowmans Johannesburg office, the dispute resolution department. He specializes in all areas of dispute resolution, including local and transnational litigation, private arbitration, and mediation. Thank you for joining, Clement. Funmi is a solicitor and advocate of the Supreme Court of Nigeria. Having been called to the bar in 1982, she is the principal of Funmi Roberts & Co. and heads the ADR unit of their dispute resolution department. And Funmi has been very closely involved with Ed and James in the design of the guide on investor-state dispute resolution that CEDR has published and is available on their website. Wilbert joins us from Arusha this morning in Tanzania. He's the managing partner of the Tanzanian office of Bowmans, and he has over 20 years experience advising domestic and international financial institutions and corporations on corporate, regulatory and transactional matters, as well as a background prior to that in academia, working in the Faculty of Law of the University of Dar es Salaam. Welcome, Wilbert.
Thank you.
And then turning to Ed, who is based in London. And Ed is the managing partner of Baker McKenzie's London office and chairs their Global International Arbitration Steering Committee, and was also closely involved with James and Funmi in the drafting of the guide. So we have a great team, not only based in Africa, but who have also considered the question of investor-state dispute resolution and mediation from a global perspective. The way we're going to work this morning is hopefully to have a conversation. And as Robin said, we'd really welcome questions and comments in the chat, which we'll address as we go along. We've got a series of questions, and either myself, James, or Chris will put the questions to our panel and also contribute from our experience. And we'll work through the questions and share with you our perspectives in that way. So please do feel free to put your questions in the Q&A in the chats as we go along. And we'll leave some time at the end for discussion as well. But we want it to be quite conversational. So I'm going to start off, Chris, with you with our first question. Over to you.
Thanks very much, Felicity. And it's a good idea to start at the beginning, I think. And I'm going to start at the beginning with Ed. And the beginning really is investor-state disputes. How do they take shape? How do they emerge? Where do you find an investor-state dispute? Where does it come about? And how are we likely to come across them?
Well, thanks, Chris, and thanks, Felicity, for that very generous introduction. And thank you to Conflict Dynamics and CEDR for the invitation. It's a real pleasure and honor to see you all this morning, this afternoon, wherever you are in the world. As you say, it's good to start at the beginning. And so what is ISDS? And while I know what ISDS is, I'm always intrigued to see what a Google search will come up with. And so I put in ISDS into Google on Monday. And what did it come up with? The International Sheepdog Society. That's not what we are here to talk about today, but it does highlight the fact that there is some misconception around the topic. ISDS, in the context that we're going to discuss it today, stands for Investor-State Dispute Settlement. And really, what is it? It's a procedural mechanism that allows an investor from one state to bring generally arbitral proceedings directly against the country in which it has made an investment. And so the context for ISDS is really an investment, foreign direct investment by one investor into another state. Now, generally, these protections arise under investment treaties, and they take a number of forms. So the most common out there, and there are probably over 4,000, although no one has a full repository, are what are known as bilateral investment treaties, or BITs, or BITs, between two states. And under those treaties, two countries commit to promote and then to protect investments made by an investor from the other country in their own territory. And those contain a number of substantive protections, which are not really the purpose of today's discussion, but they range, for example, from promises not to discriminate against a particular investor as opposed to nationals, or commitments not to expropriate other than for a proper public purpose, and most importantly, in return for fair and adequate compensation, but also a number of other protections, the broadest of which is a nebulous context of public international law called fair and equitable treatment. So these treaties contain protections. They contain also very clear definitions as to what you need to do, what characteristics you need to have to qualify as an investor. And that obviously involves nationals. For example, if you hold a passport from a state, that will generally qualify you as an investor. And if your company, incorporation, sometimes requiring a presence, sometimes just a postbox company is sufficient, can qualify you as an investor from one country. And then the treaties will have very precise definitions of what is an investment, what qualifies an investment. And that ranges from purchase of real estate and shares through to much more esoteric concepts of, rights to intellectual property, for example. And these treaties, as well as containing definitions of who is protected and what the protections are, will generally contain a dispute resolution mechanism. Most frequently, that is international arbitration, and international arbitration under a number of different bodies. James has already referred in his introduction to ICSID, which is the International Center for the Settlement of Investment Disputes, which is the umbrella body really for this whole area. It's a body that was set up by a convention of 1965 and sits within the World Bank organization. But not all countries are signatories to the Washington Convention, and so treaties will often provide for alternative fora, such as ICC or ad hoc arbitration under the UNCITRAL rules. So that's a very broad introduction to the concept. What I haven't touched upon is, as well as BITs, they're also what are known as multilateral investment treaties. And couple of examples of those are the Energy Charter Treaty, for example, that James also mentioned. Another one is the USMCA, so the agreement that's replaced NAFTA, which contains an investment protection chapter. So that's a very whistle-stop introduction to the concept, and it doesn't involve sheepdogs.
Well, I wonder, Chris, if I could take over. And it's given us a nice broad explanation and mentioned a couple of key organizations and structures: ICSID, the ECT, the MCA, and BITS, the bilateral investment treaties. I wonder if we can, at risk of generalizing, ask Clement and Wilbert to tell us a bit about how investor states are resolved in Africa generally. Because on the one hand, we have South Africa, which is not a signatory to ICSID and cancelled many of the bilateral investment treaties. And then we have other countries which are signed up to those and others. So perhaps we can just start with South Africa. How are disputes, investor-state disputes, commonly dealt with in South Africa? And then perhaps I can turn Funmi to you to ask for a Nigerian perspective.
Yeah, thanks, Felicity, for the question. So South Africa is one of the countries which has sort of taken a different stance to what other countries are doing, in that they've cancelled most of the BITs, as you mentioned, and particularly those with EU member states. And they're also not concluding any new BITs or any form of investment treaties, but they have been active under the auspices of the AFTA, where there are negotiations on the investment protocol. So it will be interesting to see what comes out of there. But what they did at the time that they were terminating their BITs is that they enacted a piece of legislation called the Protection of Investment Act, which, as Ed mentioned, has some general substantive protections, although commentators have said, they aren't quite comparable with what you find in most BITs. But moving to the point that we are discussing about investor-state dispute settlement, what the Act provides for is mediation first, and it's not compulsory. So it says if a foreign investor, there is a measure which in their mind leads, to a breach of the act, then they can inform the government, and the government department which sort of regulates the act and monitors its compliance. And then that government department, together with the investor, will then set up the mediation, and they have a list of mediators that they use. But at the same time, the foreign investor is also welcome to go to the National Courts of South Africa to institute its claim there. And then lastly, what the Act provides for is that if the foreign investor has exhausted all internal remedies, then the South African government may consent to state-to-state arbitration, which, as far as I'm aware, has not happened. But the government has been very proud of itself to say that the stance that it has taken has actually worked, because they say that they've achieved some very good results with mediation, although none of those mediations, the details of those mediations have ever been set out in the public. But I mean, it forms part of the South African government's mantra that what they're trying to do is dispute avoidance. And they say each time that an investor has come to them and said that there's an issue, they've always been able to find a solution, which I think, bodes well for mediation.
Great. Oh, well, it's really good to hear that mediation is in that range of options. Well, but how about East Africa? What is the most common approach to investor-state disputes in East Africa?
Oh, yes, thank you, Felicity, for the kind introduction and for inviting me to participate in this webinar. Now, to speak of Tanzania, let me begin by saying that my experience is limited more to Tanzania than to East Africa generally. And I can begin by by pointing out that Tanzania has signed up to the convention, the ICSID, and it has numerous bilateral investment treaties, BITs, which contain provisions allowing for investor dispute settlement through the ICSID mechanism. So they kick them back to the structures available under the convention. And the next possibility for settlement of disputes is by ad hoc arbitration. And there, the UNICITRO rules of arbitration have applied. What is also interesting in the legal regime here is that the Tanzania Investment Act, which was passed in the 90s, also made provision allowing for investors who have registered their investments under the Tanzania Investment Center to seek to resolve their disputes through the ICSID mechanism. Of course, also with liberty to settle them through municipal courts. So the regime is there. Now, I guess maybe we'll discuss this later. What has been the problem is not a problem as such. The interest of government to resolve disputes through mediation has taken a very laid-back approach. For example, as you know, once a request for arbitration under the ICSID has been notified, there is a cooling period, which gives an opportunity to the investor and Tanzania to look to ways to resolve the dispute through mediation. But in practice, government has never used that opportunity to sit down with the investors and resolve them. They've tended to end up in disputes in the various forums I've mentioned, and in the majority of cases, save for one technical case I know, government would lose many of these arbitrations. I would say the reason for that is, maybe when we discuss the challenges, is largely because there appear to be no capacity within the government structures, within the Solicitor General's office or within the Attorney General's office, to actually be able to prepare and defend the claims. Probably understandably, because in the majority of cases, the cases of expropriation or other contractual disputes tend to arise from very arbitrary decisions coming from government,
Right.
which,
Yeah, just as you say, quite a few of the frustrations, let's say, that you're beginning to allude to are perhaps the typical challenges that we're going to go to a little later, and how to actually deal with those difficulties and lack of will is something I think we need to explore. I wondered, Funmi, if you could, thanks Wilbert, I wondered if you could just comment from the Nigerian point of view, how are disputes particularly or frequently resolved? Oh, you're on mute, Funmi? Oh, yeah, there we go.
Yes, unmute yourself is one of the key words now used for online conversations. And thank you very much for the invitation to participate. What we have in Nigeria is not more different from what has recently been described for Tanzania. We use diplomatic means. I'm trying to, keep it as short and simple as possible. And that's basically through negotiation. And when that fails, we go on to institutional methods driven mainly by ICSID and ICC arbitration. And what we typically use more often than not is arbitration. And I know a bit about that because I'm not only a CEDR accredited mediator, I'm also a chartered arbitrator. And I know that for many IS disputes in Nigeria, the go-to mechanism is arbitration. And in recent times, and I'll share an example as we go along, mediation is beginning to come into the fore in Nigeria as well. So briefly, that's my contribution to that question.
Yeah.
Maybe I can pick up from there and move it forward. So it's good to hear South Africa is a bit of an outlier and leading the way in mediation, but I think what Wilbert's experience and Funmi's experience in Tanzania and Nigeria is probably typical of most jurisdictions, where arbitration is the primary route via the BITs through and then through exit. What maybe then thinking about what's leading the change to be looking at mediation in this context? What are the factors that are leading change in relation to mediation in investor-state disputes?
Can I jump in here?
Yeah, please. It was addressed to you.
Yes, thank you very much. Well, arbitration's flavor, as I said, is beginning to wane for many reasons. And I'll just talk briefly about a few of them. One of them is cost. We only need to look at the cost and the Queen Mary study and what it says about people's reaction to the cost of arbitration. It is such that there's so many, even investors who would like to go for arbitration that who cannot afford it. And then time. There was a time when you could say that one of the main advantages of arbitration is that you can get results expeditiously, but not any longer. You can be on the issue of appointment of the arbitrators for 5 years, 6 years, going from one level of judicial system to another before you can get the panel well settled in. And then another issue is the clinical nature of the arbitral process and the inability of the arbitrators to take into consideration the cultural and the socio-political nuances that often go into resolving these disputes, and which in Africa is really a big deal, which many people are unable to understand. And as an arbitrator who's been involved in quite a number of arbitrations where government is a party, government officials who would implement the arbitration agreement may not necessarily be the ones who negotiated the terms. And so there may be a serious lack of institutional memory, which then means that the state is not able to present itself or its case properly before the arbitrator panel, and which is a very, very big problem for many states' arbitrations in Africa. And more recently, the magnitude of damages that are awarded against African states. And some of them are more than the annual budget of an impoverished African state. And I'll give two Nigerian examples. And I'm sure everybody on this panel is aware of the case of Process and Industrial Developments Limited against the Federal Republic of Nigeria, when in 2016, an award of $6.6 billion was rendered against the Federal Republic of Nigeria. And this is about 33% of our country's external reserves, which at that time stood at, I think, roughly 26.9 billion. And then recently we had the Ajaokuta Steel Rolling Mills arbitration, where there was an award of, I think, 22.8 billion US dollars against Nigeria. And if you convert that to the local currency, even at central bank rate, we'll be talking about 2.46 trillion naira against Nigeria. And so what did the Federal Attorney General do? They've been on this, they've tried to set aside that award for so long. Then they now brought in ICC mediation. And this year, the 2.46 trillion naira was reduced to, I think, $496 million, which is considerably lower than what we would have had to pay out. So there's so many awards like that rendered against Nigeria. And I can say with a little bit of confidence that the Federal Attorney General is seriously looking into mediation to resolving those. And the success achieved with the Ajaokuta Steel Rolling Mill arbitration is an impetus for them to continue to use mediation. So there is a lot of work for mediators in this space in Nigeria, as well as many of other African countries. If you can just get our act together, and more importantly, if you can legislate mediation in Africa. So I'll stop and allow. So
you set out the reasons why mediation has been looked at, and I guess it's a kickback against cost of arbitration, the time, the size of the awards. And it's interesting, isn't it, that what's happening in the investor state space is probably happening in the commercial, for those working in the commercial space, happened 5-10 years ago. So it's taken a while to get to the investor state space, but seems to be happening there. Ed, maybe can I turn to you? I guess picking up, what are the key advantages of mediation for investor state disputes? I guess the flip side of some of the things Funmi covered, but there's probably others as well.
Yeah, thanks. And Funmi's covered a lot of the advantages at covering some of the drawbacks. But an amicable settlement is particularly valuable where you have an ongoing relationship. So if you have an investor who remains in the country, it's in everyone's interest for that to be resolved in a way that can mean that ongoing relationship can proceed. Fumi also pointed out to some of the cultural and political nuance. A settlement can deal with things that are not purely financial, whereas an arbitral award really is a relatively blunt instrument and does have the impact that, again, was just referred to about, valuable foreign currency having to be paid out, whereas actually if the dispute is around property rights in country, that can be resolved without having to use US dollar reserves, for example, if a settlement can be achieved. You can avoid costs and delay and distraction, right? It's bad press. Average costs for an investment treaty claim are in the range of $5 million. A mediation can take 6 to 9 months on average, seem to be the statistics we were looking at, James, when we did the report. Whereas an arbitration will last many years, particularly where it involves a state party. There's reputational and PR aspects to it for both parties, but a state in particular, a state that's keen to project itself as being investment friendly, will struggle if it has a whole number of arbitrations against it that it hasn't paid out. And I think the other two aspects I wanted to mention really go to the core here. One is an impartial third party, or two, you can have two mediators if you want, involved. And so you do get that ability to broker and to break down some of the barriers that inevitably exist when you have a dispute of this nature. And that's particularly important in an African context where disputes traditionally are very consensus driven. When you resolve a dispute, my main experience is in West Africa, so I can't speak for, and others on the panel much better to speak about other parts of the world. But the way disputes are resolved traditionally is by going to the Council of Elders, who are sort of mediators and who help come up with a resolution that no one is completely happy with, but at the same time, everyone takes away both face, but also a feeling that they've bought into the outcome. And that's where mediation can really help. In terms of drawbacks, I think the drawbacks, again, have been tough. Mediation requires two parties. It takes two to tango. And for investors, it's often very, very difficult to find someone to engage with at the government level. Politicians tend to take a very short-term view, and often they can blame the issue on a previous government, and they can let the resolution of the arbitration and the award fall on the next government. And therefore, what's the incentive for them to actually make a decision and pay out money, which they'll be shot down for? The press will have a go at them for being weak. So civil servants are very similar. They don't want necessarily to have to make a decision that could cost the taxpayer money. And again, for both of these sets of people, it's sometimes easier to do nothing, allow the process to run its course, lose, and be able to point to this saying, look, it was this other ministry that did it under previous government. We've got to pay it out. We've got no choice. And it's not unusual then to have engagement at that stage, as Fumi was describing in Nigeria. But by then, you've already got this huge award against you. The reputational hit has been had. There's every incentive to get there forward, get in there earlier and address it up front.
Yeah, and just picking up that point, authority and getting them to engage because of the risk you said, it is one of the major issues. And I think from many of the conversations I had, and I guess Clement touched on it, you need the state to have a structure in place that ensures that you can mediate and you will have authority. And I've talked to a number of countries around the world where they're putting those in place so that the state has the ability to mediate. It's clear who has authority. So it's not beyond the wit of man that these things can be resolved. But you're right to say that at the moment, it's a difficulty for many states because they haven't the systems in place.
Can I just come in there then and have a follow-on, Ed, from what you've just talked about? And that is, I think, picking up, James suggested that we're waking up in the investor state arena about, did you say 5 or 10 years after commercial actors have been thinking and realizing the benefits of mediation in cross-border disputes of a commercial, purely commercial nature? I mean, many investor states are also commercial in nature for the investor, but what are you able to sort of move from what you've just described as the sort of obvious advantages of mediation into what's different about investor-state mediation? Is it just the same? And we've just woken up a bit later, or are there some distinct differences about investor-state mediation as opposed to mediating cross-border disputes between commercial actors?
So I think the similarities are much greater than the differences. It's particularly when it comes to the process. I mean, the process for mediation is pretty fluid, as James and Felicity and you, as accredited mediators, will be able to attest. No two mediations are exactly the same because it's the parties' process, it's consensual, and therefore what the parties agree will generally happen. Having said that, the concept of there being a neutral, impartial person who acts as a go-between, and again, that can be more than one person if that's necessary, particularly where some of these cultural and political nuances really can't be bridged by a single individual. The concept of a facilitated discussion, whether it takes place over a day, whether it takes place over 6 to 9 months in a number of different sessions, it is the same. I think the biggest difference in my experience, and I touched upon this earlier, is that states are not commercial entities. They are part of the reason that this is taking time to turn is, a state is much more like an oil tanker, not a nimble yacht. When it comes to changing direction, that takes time. And the drivers are different. They're not purely commercial. When you're dealing with two commercial parties arguing over a commercial transaction, most of the time, not always, but most of the time, the key drivers are financial, commercial. For a state, they're not. They're political, they're social, they're financial, they're reputational, and they're all these political, cultural nuances on the ground, often can be quite different in different parts even of the country, and they're often issues between the part of the state, the instrumentality of the state that made the decision. Wilbert said they're often arbitrary. That's certainly the view often taken by the Attorney General's office or the Solicitor General's office, looking at this with hindsight and going, what the hell were you doing when you made this decision that I'm now having to defend in international law? And so you have all this infighting, you have the political issues that I touched upon. And so the much more difficult aspect is finding out who you should be talking to, who actually has the authority to make a decision. And in my experience, when it comes to states, it's very hard to predict that. So I've got a really good example where I was acting for an investor, and we had a claim against the state, and we had succeeded at first in ICSID, and there was an annulment process going on. And we settled it literally as I was walking to the hearing of the annulment, and I got a phone call from the lawyer on the other side to say, okay, we'll accept your offer that I made the night before. And the only reason that deal happened, and it wasn't a huge amount of money, but the only reason that deal happened was because the president of the country that we were against was going on a state visit the following month to the country where my client was from, and didn't want this to be on the agenda when they went on the state visit, right? So you just never know precisely what will be the trigger, but that is where the political pressure can come to bear. And so it's very important to have alignment between the legal strategy and the political strategy, whichever side you're on, and for mediators there to be very alive to that bigger picture.
Sorry, Ed, I just wanted to follow up on the point that you made about elders making, working in a consensus-based way with parties and coming to I guess, a kind of recommendation that they then go along with. Now, I know that in some of the structures that exist, I think in the original ICSID procedures, there was provision for conciliation. And so this distinction between kind of elders deciding, conciliation and mediation is quite important in my experience in Africa, because very often there's a confusion between the role of the mediator in the sense that we know, sort of hands-off outcome, and conciliation or elders making recommendations. So can you give us a sense of how mediation is thought of, or the role of the mediator in the mediation process we're talking about today?
Well, you're right that there is a difference between a conciliator who will make very positive recommendations, not necessarily the full outcome, but at least push the parties in a particular direction, and the context or the concept of mediation as it has emerged from commercial dispute settlement, where the mediator will test parties, will challenge each side on their case and issues that could arise and some of the challenges that they face, but without generally, unless the parties agree and ask the mediator to do that, which in my experience has been very rare, will very rarely come up with a view as to the merits of any particular issue, let alone the overarching dispute. And so the distinction that you raise is very interesting, and I'm sure there are people much better qualified than me to put that in the cultural context in different parts of Africa. But it's a small step, I think, and as people become more familiar with the concept of mediation and the work that's been done around the Singapore Convention on mediation has really brought mediation to the forefront of the international community. But you're right, the lack of a view expressed firmly does sometimes mean you're still up against the challenges that I brought up around actually people having to make their own decision. So civil servant politicians having to stick their neck out, which they might do if they want to avoid personal political embarrassment on a state visit, but they might not want to do if it's not so immediate.
Yeah, for me, how do you see it?
Well, I always say that mediation should actually take precedence over arbitration in Africa, because our elders mediate all the time, perhaps not in a structured manner as we have in conciliation and mediation. And that's why some of us wonder why we have this like a closer link to arbitration than to mediation, because mediation is cultural for us in Africa. But I see the trend changing, and particularly since the introduction of the Singapore Convention, which I'm sure we'll talk about a little bit down the line. But now that I have the floor, can I just make a point about the differences between arbitration, between mediating commercial dispute and investor-state dispute. And it is a point that we tend to overlook many times. And it is about the issue of confidentiality. Now, when the World Bank, IFC particularly finances some projects, most of these projects have issues of human rights violations there and environmental issues arising, which means that many NGOs, human rights activists are interested, and they have to be carried along in the dispute resolution mechanism. Now, for arbitration, they can come in as amicus curiae, subject to the consent of the two parties. But in mediation, where we place a large premium on confidentiality, it becomes a problem that needs to be dealt with. And that's one major difference. I know that the World Bank's complaints advisory ombudsman prefers mediation for those cases than arbitration. And one of the challenges that mediators face is how do we deal with confidentiality? Because the NGOs that are involved in those disputes want to jump in as quickly as possible. So you have to try and strike a balance between keeping the process confidential and at the same time dealing with the public scrutiny that comes into disputes that have environmental issues and human rights issues involved in them. So I just had to make that point now.
The difficulty here is the classical mediation has confidentiality, but there's a need for more transparency often in these types of cases, because often they're high profile and people need to know. So that's a balance the media is going to strike, and the parties will need to. Wilbert, maybe this turns to you as well. Any thoughts about other challenges for the parties, particularly in Tanzania and Africa, in terms of trying to set up an investor-state mediation, other than the ones that we talked about, authority and confidentiality?
Oh, yes. Yes, I did allude a bit to capacity on the side of government, and for them not being interested in getting support from international law firms to help them in the process. But that was something which occurred in a short window in the last administration, where in fact even arbitration itself was banned by statute, a statute which did not override previous legislation, which allowed for a mechanism for arbitration, and of course also the opportunity for mediation. Now, more lately, I guess for reasons, which is one of the challenge, for reasons of cost, and these costs are enormous, and they need to be approved, budgeted for and approved in advance, which then creates more delay in even funding defenses. So an opportunity for mediation becomes a lot more welcome. Now, more recently, something similar to what Fanme was saying, that the government is resorting to diplomatic approaches or means to resolve investor-state disputes, even when an unfavorable award has been handed down. So government is now actually encouraging discussions and mediation and some arrangements to compensate the successful investor in some way, like monetary compensations over a period, or maybe an offer for new investment opportunities in the state. So the challenges are all connected with financial constraints, the general business of the state when it made the offending decisions, and then capacity of state officials. And as the facility said, sometimes the usual way is to say, oh, this was decided by, decided by previous administration, and so there's nothing we can do. So in order to close down the possibility of not using taxpayers' money to dish them out to investors, the environment now is a lot more friendlier. That when disputes, I know currently there's one arbitration in which I was involved. The government this time was appearing for the investor. The government lost, and they're now in discussions about how they can do it without placing government in undue financial constraints. And then there were other disputes which arose during the period when legislation was passed to ban arbitration outside Tanzania, which means it would not be possible for investor state disputes be resolved under the mechanisms we're familiar with, like ICSID or under the BITs. So that's how I see things turning out now in Tanzania.
Can I quickly jump in, Felicity? I think you were going to come in now, but just to pick up a question that we haven't answered from Kennedy in Nairobi, who was just sort of pointing to and saying, how do you get into mediation? I know that's the topic that we're really moving on to now, how we increase the uptake. But historically, I heard you say, Wilbert, that the traditional, sort of the allocated space was that short cooling off period in the ICSID sort of process where you've got sort of 30 days and are you going to mediate? And I think I heard you say that in reality, the state, much as it's reluctant to go to an arbitration, is also unable to really develop or build a political momentum and a negotiating strategy to actually engage during that sort of cooling off period. So as a result, we've ended up getting, I think I've heard both Funmi and you talk about mediating post-arbitration, which doesn't seem to be the most efficient way to resolve a dispute, and is really also bound up with that big disadvantage of enforcement. Winning an arbitration for the claimant, winning an arbitration is one thing, you've got enforcement. So now we're, instead of mediating at the early stage, we're mediating much later, once we've wasted all of our time and money on arbitration as well.
Absolutely, which is what we want to avoid. So let's have a look at what steps can be taken to enhance the uptake of investor-state mediation earlier at a more useful stage in Africa in particular. So Clement, perhaps I can turn to you, and you've described the South African options, the options for parties in South Africa. How can we, and you say we don't hear much about the mediations that do happen. How can we, do you see any potential for changing that? How can we really enhance the use of mediation, be it through the Protection of Investment Act or through other mechanisms? How can we really get that going? Thinking South Africa, and then let's hear from others.
Yeah, I think one of the principal things that can be done, and which has come up quite frequently in the course of this discussion, is that you need buy-in from the top of governments, because more often than not, if it's a process that they feel like they are forced into, it was just put into a BIT without somebody really applying their mind to, they will go to the arbitration, to the mediation, but they'll be very passive there because they don't really expect, an outcome that might be favorable to them or the investor. They just see it, as a step in a process. So I think there would need to firstly be a policy shift in favor of mediation. And I think the people at the top, have to be educated about what mediation is, what are the benefits of mediation. And then the second thing, I think, but particularly in an African context, you would want to see more African arbitrators, because one of the contentious issues at the moment with investor-state arbitration is that there aren't enough African arbitrators. So, and I think it's quite important in a mediation context. You generally want somebody who has a better understanding of your context, why certain decisions were taken, why a certain outcome might make sense and why another might not. So I think having somebody, from a similar background as you would be quite important in a mediation context. And the third one, I think, is having appropriately skilled mediators, being the ones who conduct mediations. And this is something that I discuss with Chris quite frequently, because sometimes you find lawyers who think, mediation sounds easy enough, anybody can do it, but there's an actual science behind it. And